I'm not aware of data protection authorities directly getting involved in M&A deals. I mean, generally, they're not going to know that they're happening. Things go on largely behind closed doors. And certainly they don't know what's going to happen with the data. But what you do see is them intervening after the M&A has taken place, after a business has been acquired, and then the acquiring business essentially wants to exploit the personal data. And that's when the Data Protection Authority will step in. And I mean, you've mentioned the main example, which is Facebook's acquisition of WhatsApp, where Facebook acquired WhatsApp and then wanted to use WhatsApp data in a number of different ways, including for marketing and advertising. And that triggered all sorts of alarm bells in the data protection community. The Article 29 Working Party set up a task force because this was about what Facebook were intending to do after the acquisition of WhatsApp, rather than what they'd actually done. There wasn't scope for fines and penalties, but all sorts of legal orders. The Hamburg Authority, the French Authority, took legal action to prevent Facebook going ahead and essentially making at least some of the money it hoped to make out of the deal. And in the UK, it's actually WhatsApp, gave an undertaking to the Information Commissioner, who was critical of the use of the data on all sorts of grounds, that there was no lawful basis for Facebook to use the WhatsApp data. Facebook were supposedly relying on consent, but the consent wasn't valid, even pre-GDPR this is, that there was no proper information to individuals. And I suppose you could sum up the Commissioner's position, as it often is, basically this was unfair. And particularly as at the time of acquisition, it had been said that WhatsApp data would not be used for advertising and marketing, and this was going back on that. The whole thing was unfair, incompatible, all the sorts of things that the Commissioner talks about, a lack of transparency, a lack of control for individuals, no accountability, focusing on the individuals. So that is the prime example where things can go wrong if you don't take account of data protection properly. And as you said, the Commission, there was a €110 million fine there. Similarly, because of going back on the promises that have been made about how the data was used, and the German antitrust authority has been involved in the same issue, exploitative abuse of a dominant position. But there are others. I mean, going back a bit, again, it's a little bit hard to pin it absolutely on mergers and acquisitions. There's Google. A few years ago, there was, again, task force of data protection authorities taking action against Google over its privacy policy and over bringing data together from all sorts of different sources, at least one of which was YouTube, which was, had been acquired by Google. So again, this actually happened. The privacy policy was inadequate. There were fines in France, in Spain, Italy, the Netherlands, UK. At that time, the criteria were different. You had to show substantial damage or distress before fining, so there's no fine from the ICO. But again, Google gave all sorts of undertakings and made changes to its privacy policy at that time. So you do see regulators, I suppose, sort of stamping on what you'd hope to get out of the merger or acquisition. Which ought to drive thinking back into the process, as you say. I think, from what I see and the work I've done with Alan and Overy, I'm like you. I haven't seen any mergers and acquisitions that I can say have fallen apart because of data protection. But I do see a level of caution, and a level of caution which is greater now than perhaps some of the discussions I had with people, 5-10 years ago, where at that time, I think the general view that I got was, look, you're in a merger and acquisition. There are always risks. There are risks about the business you're going to acquire. You never quite, it's like buying anything. You never quite know what you're going to get and whether it'll work out. But these are multi-million-pound transactions. Data protection's a little bit of risk. and it's pretty small amongst the totality. And at the end of the day, data protection is unlikely to get in the way of you doing the deal. I suspect that's, as you said, that's changing because the consequences of you not being able to use the data in the way you hoped, and the idea of these huge fines, which this is perhaps the area where you could get to these 4% of turnover, because it's linked to competition, and the idea of these high levels of fines is drawn from competition law and about unfair competitive advantage in a market and so on. And so that might change your thinking. And I've been in some of these. One of the things I do at Overy is, if Overy is representing a business which is trying to acquire another one, they ask me to have a look at the data. And, forgive me, sort of, are these data tainted? Will we be able to use them? And I've seen ones which have stopped. At that point, I can't say. I'm not close enough, and I don't know. I can't say it's because of the data. One of the things I can say is, sometimes these are not. Well, these are multinational sort of deals, and you can have a US business trying to acquire someone in Europe. And forgive me, they don't understand what personal data is. So they think they're acquiring something which is not personal data. And, oh, yes, it is personal data. And the mindset starts to change.